All right, we're now moving into the materials that are contained within the handouts, so the notes, note 6. There are several of them. They correspond with week 6 on the calendar, even though we missed that due to the storms last week. But that's where we are, and we're going to talk about those notes, which basically deal with the rights of homosexual and lesbians and homosexual and lesbian couples, the right to same sex marriage, and what the court has done so far in terms of rights for transgendered people. Now, I'd like to start off with the case of Obergefell versus Hodges, which came down from the United States Supreme Court in 2015. And it was in this case that the court found that states could not deny a marriage license to a same-sex couple on the basis of equal protection, saying that it was a form of discrimination against a suspect class of people to preclude same-sex couples from being able to marry. There was certainly history behind this. The decision didn't appear out of thin air, and maybe going over a little bit of that would be helpful to see how developments have come about and what the court was actually thinking on this. The earliest legal action in this area was in 1993 in a case called Bear versus Lewin. The Supreme Court of Hawaii found that under Hawaii's own constitution, under their own view and definitions of equal protection, that the state of Hawaii could not discriminate against same-sex couples in the issuing of marriage licenses. So basically, the right for a same-sex couple to marry came into existence in Hawaii in 1993. Now, interestingly enough, in Hawaii, there's something called initiative. An initiative is the idea that a group of people or a citizen can come up with a proposal to either amend the state constitution or to amend state law. They can put that in the form of a petition. If they get enough registered voters to sign that petition, then that proposition shows up on the next election as an item to be voted on by all of the voters. And if a majority of voters agree with that proposition, then it becomes law, it becomes a constitutional amendment. Rhode Island does not have initiative. Massachusetts has it in a very limited form, but this is something that's quite common, quite popular in the western states, and very often in the last 30 or 40 years, a number of different changes in the law have come about when courts and legislatures don't want to move, and citizens take it upon themselves to begin these campaigns to put something on the ballot and get it done. The voters in Hawaii were not particularly enamored in 1993 of their Supreme Court's decision to legalize same-sex marriage, and in subsequent years there was an initiative that was placed on the ballot that basically said that under the constitutional rules of Hawaii's constitution, marriage was between a man and a woman and had no other definition. So after it had been legal for a while, same-sex marriages became illegal again within the state of Hawaii. Now, the fact that Hawaii Supreme Court reached this decision caused a great deal of consternation and concern among a number of people, a number of citizens, a number of politicians, and in response to that, and there are a couple of reasons for that before I go into the response. One is something called the full faith and credit clause. The Constitution of the United States makes it very clear that every state in the country must follow the actions and rules and court decisions of the other states. It is for this reason that when a couple gets married in Rhode Island and then moves to Virginia, they do not have to have a second marriage ceremony in Virginia. They don't have to take out a marriage license in Virginia. The fact that they were legally married in the state of Rhode Island and recognized by Rhode Island as such means that the state of Virginia must recognize their marriage as well. This is such an accepted concept that we don't even think about it today. We move around from state to state without really realizing that we're changing legal jurisdictions and that could have significant right changes. However, because of the full faith and credit clause, it does not. So again, if you are divorced in one state, that divorce is fine. Once it becomes final, it's valid in all other states. Think of any type of regulation, different types of rules, different types of laws, court decisions. The Constitution says they must be followed one state to the other. The Supreme Court has been fairly diligent over the years in enforcing those types of things. There are exceptions. Take attorneys, for example. We must obtain a license in each state where we wish to practice. The courts have held that that is not something which comes under the full faith and credit clause. Your driver's license is not valid if you move from one state to another. However, it is accepted as valid if you decide to take a cross-country trip from Rhode Island to California in your car. You do not need to get a new driver's license issued for each state that you drive through. Or people who live in this part of the country, if you well, the states are so small. You live in Rhode Island, you work in Massachusetts. You do not need to get a driver's license in both. As long as you have a valid driver's license in the state where you reside, you can commute into the other state even on a daily basis. And again, under the full faith and credit clause, the other state, second state, has to accept that. The other thing that caused, particularly on the federal level, consternation among the bureaucrats and the politicians is the reality that for the first 200 years of its existence, the Constitution was basically silent on ideas of marriage, childcare, education. Those are all areas that were left to the state, in the state jurisdiction. You could not get a divorce in federal court because that was held to be a state subject matter issue, and only the state courts and state laws and state rules could deal with that. And a great deal of the federal bureaucracy, who's entitled to Social Security benefits, who's entitled to file joint tax returns as married couples, who's entitled to award settlements in certain types of federal torts cases, left it up to the states to determine who was a spouse, what was a spouse, and the federal law would just recognize what was happening in the state. In 1993, there were many people, many politicians who did not want to recognize same-sex marriage, and that caused the Congress to move into action. And in 1996, under then Democratic Bill Clinton, who was seen in those days as being rather liberal, center to liberal, and I believe under at least one house of Congress being controlled by the Democrats, on the federal level, they passed something called DOMA, the Defense of Marriage Act. And what DOMA said was, for the first time in constitutional history, it said that federal agencies, the federal government was forbidden to recognize same-sex marriages, even if state law recognized them and the states that these couples were living in gave them the rights and benefits of heterosexual couples. The federal government, the IRS, the Social Security Administration, federal employees in terms of their pensions and health benefits, these rights were not to be extended to same-sex couples. They were not to be treated as married. The federal government basically, through this law, could only acknowledge a marriage license that was issued to a man and a woman, and same-sex couples were excluded. In 2003, case of Goodrich versus the Department of Public Health, the Supreme Judicial Court of Massachusetts, again, ruling under their state constitution and under their definitions of individual liberty and equality, determined that Massachusetts could not deny marriage, legal marriage, licensed marriage to same-sex couples. Things began to move along, and either by statute or by court decision, a growing number of states began to accept same-sex marriages and began to issue marriage licenses for the same. And more and more pressure came to bear upon the politicians and upon the courts to acknowledge this as a reality and to accept it as part of our legal process and our legal systems. The first real blow to the anti-marriage, same-sex marriage folks came in 2013 in a case called U.S. versus Windsor. And this, again, was a Supreme Court case. And in this case, the court struck down the Defense of Marriage Act, struck down DOMA. It was a very interesting case here. Uh, Two women had been a couple for many years. New York, they lived in New York. New York finally changed their laws to allow same sex couples to marry. The women were rather advanced in age, but they married, and they, under New York law, were recognized as spouses. One of them was rather wealthy, and she, unfortunately, died first. And under New York law, there were provisions saying that there would be no inheritance taxes between spouses, so they were good to go there. The surviving woman did not have to pay inheritance taxes under New York law. And the federal inheritance tax law actually said that there was no inheritance tax to be assessed between couples, married couples, but if money was left to anyone else, children or friends or anyone, any other types of relatives other than a spouse, then the inheritance taxes would apply. The woman who died had enough money that we were talking about a $300,000 inheritance tax bill that the federal government, the IRS, was claiming was due to them because even though they were married under New York state law, the IRS under DOMA was forbidden to acknowledge that marriage and had to treat the money as if it had been left to a friend or some other type of relative, whereby the federal inheritance tax would apply. When there's $300,000 at stake, you will hire the lawyers to protect your interests and to move your case forward, and that's what happened here. And when it reached the Supreme Court of the United States, the Supreme Court basically said that DOMA was indefensible. It was creating an arbitrary distinction between people. It was creating a suspect classification, and therefore, under equal protection rules, it would fall. The court applied both due process and equal protection rulings or ideas in the Windsor case. It was not long after that, 2015, only 2 years later, that the court took up Obergefell. And actually, in Obergefell, there were a number of cases consolidated into one, several different couples who were seeking to have their marriages recognized. All the cases were taken together by the court. And basically, again, the idea was that under concepts of equal protection, the states had no right to create a classification of same-sex couples versus heterosexual couples and to treat them differently, that there was no rational basis for doing this, and therefore the states, any laws that prohibited same-sex marriage should fall, and any states that allowed marriage of heterosexual couples had to extend that right to same-sex couples. The court had an interesting time with this case because one of the things that you have to realize is that historically, for the 5,000 or 6,000 years that we have written history of civilization, marriage had always been considered in most societies to be between parties of the opposite sex. There were different societies that practiced polygamy in the past where you could have more than one partner, usually that was very patriotic, and only a man could have multiple wives. But there was no history of any recognition, legal recognition under any type of government of marriage between two people of the same sex. So the court was really coming up against a long historical and religious tradition here in trying to move forward in this area. Now, the court laid out a number of different reasons for its decision. They went back to a case called Griswold versus Connecticut that we looked at a little bit in the right to privacy cases. Griswold was one of the cases where the state of Connecticut denied even married couples the right to obtain birth control to prevent conception of a child as a result of having sex. And in 1965, the court had thrown that out, Connecticut's law out, saying that within marriage, the right to privacy in terms of this intimate relationship between a couple was no place for the government to be, and therefore any law saying that birth control is not allowed could not stand. And that was basically, again, it was basically a right to privacy, but it utilized due process and equal protection of the 14th Amendment to get that right of privacy to apply to the states. Now, knowing that they were going against the tide of history and the deeply held beliefs of many, many Americans, the court was very careful here to lay out reasonings for what they were doing. And in one part of the case, they kind of went, again, this is, I would probably say this is dicta, that idea of this is the court just kind of patting itself on the back or putting its own ideas into a decision and not really as part of the basis for a decision. But they cited 4 aspects of marriage. One, they said, was the right to choose your partner is inherent in the concept of personal liberty. They said marriage is important to safeguard children, that marriage exists to support a 2-person union that is unlike any other, and it's important to the individuals involved, and that marriage is a fundamental right inherent in the liberty rights of a person. So again, there is no right to marry stated anywhere in the Constitution or the Bill of Rights. So much as they did with the right of privacy, they're looking to what rights were held by the people regardless of what was set up in the Constitution, what was set up under state law, and they're basically moving into that realm of these are historic and traditional rights that have been held by the people, and therefore the state should not have the power or the ability to infringe upon them or to impede them. Now again, historically, they're on shaky ground in a certain sense because no society on earth had recognized same-sex relationships as attaining the status of marriage. The court also talked about how at times constitutional rights need to be explored, need to be not really redefined, but basically they gave credence to the idea that our understanding of what these fundamental rights are may develop and may change and may broaden over time, and they kind of use that as a justification for what they were doing here. All right. They quoted language, again, from some of the right to privacy cases, some of the abortion cases, that said that in addition to the liberties that were laid out in the Bill of Rights, that there are certain personal choices central to individual dignity and autonomy, including intimate choices that define personal identity and beliefs. And they basically said that these were fundamental rights, and again, under due process and equal protection, the states could only tread on these fundamental rights very carefully and only for superseding reasons. All right. The court went on to say that the reality that a majority of Americans or a majority of the state legislatures and even Congress did not agree with this reasoning did not in itself mean that these rights did not exist. They went back to as far as 1943 to quote from a case called West Virginia versus Barrett, the idea that our constitutional scheme of government exists to protect not only the majority, but to guarantee that fundamental rights are not denied to minorities. And of course, that would apply here. Same-sex couples represent a minority in our population, and here we have the state treating them differently, creating a classification based upon their relationship and treating it differently from that of other heterosexual couples who probably make up the majority of the population. So it comes up with this idea that constitutional scholars and lawyers rely on greatly, which is the idea that one of the reasons for the Constitution and for the Bill of Rights itself is the idea that not only is it protecting the rights of the majority, but it's also protecting the rights of the minority. And the majority cannot, just by a vote or by an action of the legislature, undo the fundamental rights of the minority, because this is what we feel like doing at this point in time. An important restatement of really the whole concept that exists in terms of equal protection, in terms of races, in terms of the idea of black minority versus the white majority. this concept that the Constitution is here to protect the minority as well as to ensure the rights of the majority. Um, the court, knowing that they were on shaky grounds, even went so far, again, in dicta, not necessary to get to the opinion in Obergefell, but I guess they felt they needed to justify themselves, responded to a number of the amicus briefs that had been filed and a number of the public commentaries made particularly by religious folks who did not believe that same-sex marriage was allowable, was moral, was religiously appropriate, and were very much afraid that by giving fundamental rights status to same-sex couples, they would quickly be in a situation where their religious beliefs and practices could come under question and come under challenge. The court made a point of stating that the First Amendment protections were still here, still existed, and were sufficient to protect the rights of people of certain religious beliefs and persuasions who may not agree with same-sex marriage, and therefore they had no problem with extending and recognizing this fundamental right, even in view of those objections. Now, it's interesting when we get into Masterpiece Cake, the Masterpiece Cake Shop case, which came down only a couple of years later, we're smack in the middle of that argument between equal protection and First Amendment. And I hate to tell you, but to this point in time, that has not been adequately answered and still remains to be seen how the courts are going to actually deal with that when push comes to shove. And I'm confident, although I don't have names that I can give you, I'm confident there are a number of cases working their way through the lower courts right now that will be dealing with that issue of First Amendment versus equal protection. Chief Justice Roberts wrote the dissenting opinion in this case, the major dissenting opinion, and he was quite vocal in his opposition to what the court was doing here. He came right out, stated that the right to marry is not enumerated in the Constitution or Bill of Rights, and that in finding fundamental rights that are not written in the Bill of Rights, the court should proceed cautiously and not just start claiming that anything and everything that people might want to do is a fundamental right. He went on to give a history of cases where the Supreme Court found supposed fundamental rights only to overturn them at some point later or to have them overturned by constitutional amendment. First and foremost of these was he cited the Dred Scott case, saying that in Dred Scott, the court basically said that slave owners had a fundamental right to treat other human beings as their property, and that the federal courts had no right or power to intervene, and the Constitution could not control that. And of course, we all know the disaster that Dred Scott led to and how it was repudiated some 10 years after it was handed down by the enactment of the 14th Amendment. He cited another case called Lochner versus New York, where the Supreme Court, using the idea of fundamental rights and the right to contract, throughout New York State's attempt to pass minimum wage laws and child labor laws and maximum hours of a work week laws. When these statutes were first being introduced in the 19 teens and 20s and 30s, the courts were very hostile to them, and again, found a fundamental right of employers and employees to negotiate and contract between themselves without any control or regulation by the government. And of course, coming with Franklin Roosevelt and the New Deal and his threat to pack the Supreme Court suddenly got religion and decided that these types of laws were constitutional and were appropriate in our system. So again, Roberts cites those as another situation where the court laid down supposedly fundamental rights that had always been here and would be here forever, and a short time later were being overturned by the legislatures and by the courts. Roberts said that fundamental rights should be objectively, meaning they're not personal, they're not subject to whims or moods or the time of the sentiments of the time. They should be objectively and deeply rooted in the nation's history and traditions. And he claimed that the court had changed the definition of marriage without admitting that that's what they were doing. He said the case could not be based on a right to privacy, as here, the parties were not dealing with their relationships that go on in their bedrooms and privacy of their own homes and their personal relationships. Here, by seeking a marriage license, they're seeking state approval for something they're doing. So you can hardly say that this is private. So he basically trashed the idea that this fit under the right to privacy decisions. And interesting enough, because Roberts is not usually terribly emotional in his decisions, and does not very often reveal his hand about his feelings on things, but his final statement in the dissent was, "You may celebrate the results of this decision or this case. Do not celebrate the Constitution because it had nothing to do with this." So needless to say, even though this has come down, it is the law of the land, it is precedent, it did not come down without issue and without some consternation on the part of the people, including judges and legislators, who did not believe that this is an appropriate use of the Supreme Court's powers.